Good afternoon, everyone, and thank you for joining us for the Oxford Internet Institute's Wednesday webinar featuring Professor Sandra Wachter, Associate Professor and Senior Research Fellow at the Oxford Internet Institute, who will be examining why fairness cannot be automated, bridging the gap between EU non-discrimination law and AI. A little housekeeping. We are fortunate to have a varied audience with a wide range of views, and we request that the opinions of others are respected in this space. For your awareness, this event is being recorded and will be posted on our website following the event. There will be a time for a Q&A session at the end, so please do pose any question using the Q&A tab at any time, and please keep questions as concise as possible. These will be visible to all attendees, and we will endeavour to follow up any unanswered questions. Please allow me to introduce Sandra.
Hello, everyone. Thank you, Isabel. Thank you so much for the introduction. Hello, everyone. Thanks so much for making the time to tune in today and give me the opportunity to talk about my latest work. Before we start, I will try to share my screen, and hopefully that will work. So this should be working now, unless I hear anything to the contrary. I hope we're going to be fine now. Yes, welcome everyone. The topic of my talk is why fairness cannot be automated, bridging the gap between EU non-discrimination law and AI. And the talk is centered around two of my latest papers. One paper with exactly the same title, which was co-authored with two of my colleagues, Brent Milstead, who is an ethicist working here at the Oxford Internet Institute, and Chris Russell, who is a computer scientist working at the Turing Institute in the University of Surrey. I'm a lawyer by background, so this was a quite interesting piece to write, where we tried to explore what fairness actually means from three different perspectives. If anybody is interested in that topic in more detail, the paper is publicly available on SSRN. You can download it for free. I'm very excited to hear your views on that and happy to receive any feedback. So I'm going to talk a little bit about that paper. I'm also going to talk about a little bit about another piece that I wrote a couple of months prior, which is called Affinity Profiling and Discrimination by Association in Online Behavioral Advertisement, which also deals with the question of how targeting can lead to unfair and undesirable outcomes. Also publicly available on SSRN if you want to have a look. Again, very happy to hear your views on that. Before I start, I would love to give you a brief overview of the topics that I would like to discuss today. The first part of the talk will focus on AI fairness and why it cannot and should not be automated. In the second part, I'm going to take a different route and talk a little bit about why fairness should be automated. And the third part is trying to reconcile those seemingly competing notions, and I will try to explain how we can square that circle. Great, so let's get started. I think most of you will be aware that whenever you talk about artificial intelligence and algorithms, that fairness is an immediate problem that comes to mind that needs addressing. But I wanted to give a couple of examples to show you why I personally care about fairness and non-discrimination and make the case that this is an urgent topic that needs to be at the policy agenda on a global scale. So a couple of examples here that show the potential risk that AI brings. Interesting example here from 2020 that shows that if you're a woman, that could be lethal if AI is being used. Interesting example here where a health app is designed to detect heart diseases. And the problem here is that most of the time in the past, heart diseases have been seen as a men's problem, a men's illness. So the data that has been collected in that setting were predominantly from men, which has the consequence, if you use that biased data, that those apps are very good in detecting heart diseases for men, but they are not very good when it comes to female users. So a female user, for example, uses the app, will report symptoms like having pain in her left arm, having pain in her back, and because the data is biased, the app might just say, oh, this looks like depression, maybe you want to see a doctor the next couple of days, when in fact that person might actually have a heart attack, and therefore the bias in the data could actually have lethal results for women. So a critical problem here. Another example here from 2018 shows that if AI is being used for certain purposes, it could mean that being a person of color is equated with being a criminal. A very interesting example from the Civil Liberties Group conducted experiment where they used Amazon's facial recognition software, and they compared pictures of federal lawmakers in the US with pictures of a database of publicly available mugshots. So they were comparing pictures of people serving in Congress to pictures of people who have been arrested. And using a facial recognition software, it showed that it disproportionately misidentified African American and Latino members of Congress as criminals. So you can see that there is a racial bias here that is not to be underestimated. Third example, I want to talk about how AI can have very pervasive consequences for our society is this example here from 2011, where being gay can be acquainted with being a sex offender. Interesting piece that was written by somebody that was downloading Grindr, which is a dating online app for gay people. And when that person downloaded the app, the App Store was recommending other apps that could be related or relevant to the application that he just downloaded, and the sex offender search app was recommended to them. So that means that having an interest in gay online dating has similarities with being a sex offender. So you can see how pervasive and unfortunate and discriminatory those results are if you're using biased data. So it should be at this point very clear that we have to take this issue very, very seriously. Okay, so we know all of this, and these are just three examples that exemplify the need for regulatory action. And there has been a lot of backlash in the community, and tech developers and computer scientists and engineers around the world started asking the question, what should we be doing? And this is the part where I try to talk a little bit about what things cannot and should not be automated. So as I said, there was a lot of backlash, and obviously the tech community started asking questions in the sense like, okay, you want fairness. Let's talk about fairness. Tell me what fairness actually means. And if you talk to a lawyer and ask them, well, what is fairness? A lawyer will tell you, well, I don't know. We don't really have that concept. We don't know what fairness means. What we can offer is something that is called non-discrimination law. That is probably the closest thing that you're looking for. The tech community would come back and say, well, okay, then tell me what is discriminatory, what is unlawful discriminatory behavior. And the lawyer would again say, well, it depends. It depends. It depends. And that is a very unsatisfactory answer for somebody who is trying to encode fairness into code. But the problem is that this is how the law is actually designed. And as we'll show you at the end of this presentation, this is actually a good thing and something that we need to deal with. So I really want to talk a little bit about how non-discrimination law is established in the European Union and tell you about the contextual elements that make it what it is. I assume that some of you will have heard of non-discrimination law, but just to give you a little bit of background around that, what we're actually talking about. If you look at non-discrimination law in the European Union, what you will see is that we have two types of discrimination that we want to prevent. We have direct discrimination and indirect discrimination. Direct discrimination means that somebody is treated less favorably than others in a similar situation based on a protected attribute that they possess. So, for example, I'm not giving you the job because you're a woman. That would be direct discrimination and probably illegal in most cases. Trickier is the question of indirect discrimination. Here you would use a neutral provision criterion practice, apply that to everybody equally without using a protected attribute, but it just so happens that using that provision criterion practice poses a particular disadvantage on a protected group in comparison with others in a similar situation. That sounds very abstract, but it makes a lot of sense if I just give you quickly an example. If I told you that I'm only hiring people that are taller than 2 meters, I'm using a neutral provision, height. Height is not a protected attribute, but you will immediately know that at least women will be at a particular disadvantage because on average we're shorter than men. So that is the 2 differences that we have in non-discrimination law. It's also important to know that non-discrimination law is not exhaustive. We don't have one non-discrimination law that covers all sectors and all groups. We have roughly 3 buckets. We have the bucket of ethnicity, the bucket of gender, and the third bucket is based on religion, belief, disability, age, and sexual orientation. And depending on what a group you're interested in, you will see that the scope will also differ. We have the broadest protection when it comes to ethnicity and the least protection when it comes to religion, disability, age, and sexual orientation. This is not to say that the member states couldn't have more protection if they wanted to, and sometimes they do, but I'm talking about the directives that we have in the European Union. We've given the minimal standard that we have. Member states can have more, but they don't have to. So what you end up with is that you have 28 different interpretations of one directive, which again makes it very hard to automate that because we don't have one coherent version of non-discrimination law in Europe. Again, very, very abstract, but let me give you an example and to walk you, that helps me to show you and walk you through the different steps that you would need to overcome in order to bring a claim in court. So let's say that you find a very interesting job advertisement on the internet. You see that somebody is looking for a chef in a fancy restaurant, dream job. You want to apply for it. The only thing that you will see is that one of the job criteria is that you will need to eat pork. So when I tell you that story, I get asked the question, do you think that particular job advertisement could have potentially discriminatory effects? And the answer is, well, it depends. What does it depend on? Well, you could make the argument to say this is direct or indirect discrimination. You could make the claim, for example, that it is direct discrimination. The first thing that you could argue is that having a requirement in a job that requires you to eat pork could put Jewish people at a disadvantage. And you could make the argument that actually this is as good as direct discrimination. Making people eat pork is almost as has the same exclusive power as it has to say we're not going to hire Jewish people. That could be direct discrimination. You could also make the argument, well, actually, it's more likely to be indirect discrimination because eating pork and being of Jewish faith is not synonyms, is not the same thing, but it will have an indirect, a negative effect on the Jewish community much more than others in a similar situation. You can make both arguments. And the question is, what's true? And the answer is, it depends. The court, for example, has ruled in such instances that it depends, and it's up to member state law and the courts in member states to decide whether it is direct or indirect discrimination. So there's an element that is very hard to automate because there is no clear answer for it. The next element that you would need to show is that you have suffered a disadvantage. Let's just say you have settled on the fact that this is indirect discrimination based on being Jewish. You will need to show that you have suffered, and showing that has a contextual component to it. There is no fairness as such as a standalone right. Fairness is always contextual, and fairness is always based on an element of comparison. You don't have the right to be treated in a certain way. You only have a right to be treated, not to be treated less favorable than somebody else. So you need to find somebody else that has an advantage and you have a disadvantage. That's the thing, that's the thing that you're willing to do. So you need to show that you're part of a disadvantaged group, that you suffer, and you need to show that somebody else is treated better than you are. And again, all those elements are highly contextual, and this is why we call it contextual equality, a phrase that we coined in the paper. So going back to our example, when it comes to people of Jewish faith, you need to show that you're part of a disadvantaged group. Well, so Jewish faith, what kind of protected group is that? You can make the argument that being Jewish is ethnicity, you can make the argument that being Jewish is religious beliefs. Which one is correct? It depends. Both of them are equally allowed on member state law. Some member states have decided that Jewish faith is ethnicity. Some have said it is religion. Again, depends on 28 different interpretations in the member states. And it makes a difference because, as I said, depending on whether you're basing your claim on ethnicity, it will have more protection. People that are being discriminated based on religion have less protection. So where you put yourself makes a difference in the type of protection that you actually get. And this is not just with religion, it is with almost every protected group that we have, because those protected groups, at the end of the day, are social constructs. For example, transgender people. Does transgender fall into the realm of sexual orientation, or does it fall under the realm of sex discrimination? Some member states see the sexual orientation, some see the sex discrimination. Again, depending on where you put yourself, you get more or less protection. Scientology. Is Scientology a religion or not? Depends on what the member states have decided, depends on the case law in the member states. Ethnicity. Is being Black an ethnicity, or is there, do you need to show different aspects around that to make it to make a claim? Unclear. Member states' law completely differ. Disability. Is being obese a disability or not? So again, very contextual. There is no clear answer, and you will see 28 different interpretation of member state law and case law. So very, very hard to to automate that kind of particular problem. But let's just say in our chef example, we settle on that Jewish faith is based on religion. Next step we need to do is to show that you have suffered a particular disadvantage. What does particular disadvantage mean? You need to show the nature of the harm, the severity, and the significance. And again, what do those things mean? It depends. For example, do you need to show an abstract or a concrete harm? With the job advertisement, do you need to show that having a pork eating requirement in the job advertisement actually deters Jewish people from applying? Or is it enough that you can make the argument that there's an abstract danger for that to happen? Answer, it depends. This is exactly what the court has argued in many, many cases. It depends. There is no clear-cut rule around that. The next problem is the question of severity. Is having one job requirement that says you have to eat pork, is that severe enough to say that this poses a disadvantage of the Jewish community when you have, for example, 7 others that you could actually satisfy? Do you need to have more than 2? Does it need to be all of them, or is 1 actually enough? Answer, it completely depends. Is this a long-term type of inequality, or is it just something that is shortly lived? Again, it depends. And lastly, the significance. You, as I said, you need to show that the group that you're part of is suffering more than other groups in a similar situation. How much more do you need to suffer than others? How much significance you need to prove? And again, here the court doesn't give you a clear-cut answer. They don't say 60%, 70%, 90%. They use very vague terms such as significantly more, far greater number, considerably more. All those things are very mushy and malleable and actually don't give you a clear-cut answer. Again, extremely hard to automate that because you don't have clear-cut rules around that. But again, let's just say you overcome this hurdle. You show that you're part of a protected group. You show that you're suffering a disadvantage. The next thing is you need to show, as I said, that somebody is treated better than you are in a similar situation. So you need to find somebody that actually has an advantage in that process. How you figure that out? 2 things you need to show is you need to define the reach of the contested rule, and you need to find a comparator that is in a similar situation. Why do you do that? You need to figure out how that rule, for example, the job advertisement that says you need to eat pork, is affecting a population. That is the population. And then within that population, you need to figure out how people are being advantaged or disadvantaged around that. Traditionally, that wasn't such a big problem. For example, if you're fighting against a law, let's say in Germany, then the reach of that rule, that law, that German law, is all the Germans. If there is a law that only applies to Bavaria, then the reach of that rule, that law, is only people living in Bavaria. If you have a collective agreement, then the reach of that collective agreement is only the people of a particular trade, and so on, right? Now, figuring out who is affected by that rule, that practice of job advertisement in the online world is much more difficult. So, for example, the job advertisement example, what is the reach of Google, right? Having a job advertisement online could actually affect people on a much global scale. You could make the argument, well, everybody is able to see it on the internet, so the effect of that rule, that advertisement, is actually a global community. You could also make the argument to say, well, actually, the people that are affected by that rule are only the people who actually saw the job advertisement. You could also make the claim and say, well, actually, it's just the people who applied for that job. You could also make the claim and say, well, only people who were qualified in the first place were affected by that rule. You could also make the claim and say only the people who were invited to an interview are affected by it. Or you could say only the people who were offered the job. You could also say Google has nothing to do with that at all because it's the employer that made that job advertisement discriminatory. Or you could say it's both. And again, the court has ruled in many, many different directions. It's not very clear. Again, it completely depends. Very hard to automate. Again, let's just say you found the reach of that rule and you say this is the population that I'm interested in. This is the potential rule that is affected by those job advertisements. You need to find somebody that is actually benefiting from it, somebody that is treated better than you are. So you're saying, I am of Jewish faith, I'm in this community. If I hadn't been Jewish, I would have had an advantage. So you need to find a group that is treated better. Therefore, your group is actually smaller and everybody else is benefiting from it. Going back to the pork example, you can say, well, it's definitely people of Jewish faith. It's probably also people of Muslim faith as well, because they also don't eat pork. So we already have two communities that are being disadvantaged. You could also make the argument that it includes vegans. For example, as I said, we have protections around religious beliefs. You could make the argument that this being vegan, being vegetarian, is some sort of a belief. Should that be protected under non-discrimination law? What if you find statistical evidence that shows that atheists or agnostics don't eat pork on average, and all of a sudden your group that is being disadvantaged is getting bigger and bigger and bigger? You have vegans, you have the vegetarians, you have the Muslims, you have Jewish people, you have atheists and agnostics. And all of a sudden, the people who are actually benefiting from it is getting smaller and smaller. And it's going to be very, very hard to bring a claim because the law doesn't tell you you need to treat everybody in a certain good way. It just means you cannot treat them worse than others. Treating everybody the same in a very bad way would be legal under the law, and that is the problem. So to sum this section up, non-discrimination law is about contextual equality. It's not really clear what fairness means. It's not really clear what discriminatory behavior means. It depends on the judgments of the Court of Justice. It depends on the national courts and the member states. It's decided on a case-to-case basis. All those elements, who is in a disadvantaged group? Are you suffering enough? Who is benefiting from it? What statistical evidence is allowed? What evidence can you bring in court? All of that is decided on a case-to-case basis in the member states most of the time, but also in a distributed nature by the Court of Justice. So very, very hard to have clear-cut rules. That's why we say contextual equality. But here's the point. This is a feature, not a bug. And this is one of the reasons why computer scientists are often very frustrated with the legal community, because that contextual nature, that agility that allows you to assess it on a case-to-case basis, taking a lot of things into consideration, is what makes the law effective from a legal perspective. But it makes it very, very hard to actually embed that into algorithms because it's not zeros and ones. So this is the first part to say. things around fairness cannot and should not be automated. That's not what the law really wants. However, now it's time to contradict myself. I will now make the argument that actually fairness should be automated and that it's very important that we automate certain parts in the future. Why? As I said, non-discrimination law is based on contextual equality. That means we're assessing on a case-to-case basis. Judges in the past and currently are very often using intuition, common knowledge, and obvious facts and convictions to assess a case. And that is good, and that is fine, and that has always worked. And why? Because it's around real life cases. It's about the actual social inequalities in the world that are very, very apparent. It's human treating other human in a very disrespectful way, and you will immediately know how their behavior, their actions, their stereotypes are affecting a certain community. You don't actually need data to back that up. To give you a couple of examples around here, if I told you that an employer is banning headscarves from the workplace, you will immediately know that this will have an impact on freedom of religion. You don't need to see any statistical data on that. That action, banning headscarf, your social gut will immediately tell you that there could be a potential problem. Another example would be here, if there was a law that only grants social benefit to married couples, you will immediately know that this could have discriminatory effects based on sexuality. Again, you don't need to see the data around that. It will be very clear that this has a problem for same-sex couples at least. Lastly, if I tell you that only people with short hair are going to be hired, you will immediately know that on average, this will put women at a disadvantage because on average, women have longer hair than men. All those cases are actually case law, right? So this is not just something I made up. Actually, cases that were brought before the courts that just show the measures taken by employers, by states, by people have an immediate connection with a protected group, and you can see how that behavior can be discriminatory. Enter algorithms. Algorithms are different than humans in the way that they discriminate. Algorithms, in comparison to humans, are more abstract and more subtle and intangible, and use non-intuitive steps to discriminate against people. And that is a problem because all the legal tools that we have were created to investigate, prevent, and punish discriminatory actions of humans, not algorithms. So the tools that we have don't easily translate over to AI because they had a human perpetrator in mind and not an artificial intelligence. So to give you two examples here, what are two things that immediately make sense in a human-human setting if you want to be successful in court? You need to, as a claimant, you need to show that you are discriminated, and you need to have a feeling of being discriminated. That is the whole point of discrimination law. You as an individual feel that something is off. You're being told you're not getting the job because you're a woman, or you see that you find yourself in such a toxic environment that makes it impossible for you to succeed, and you feel this injustice and you take it to court, right? And actually, in the past, it has been quite hard or harder for discriminators to exclude you if they wanted to come back to the job advertisement example. What can you do to deter certain communities from applying to your job? Right? You can come and cut a hole in the newspaper. Obviously, nobody will do that. You can make a different thing, and you just advertise those jobs in newspapers where you know that those communities won't have access to it. So you only sell papers in quarters where there is no great Jewish community, for example. Or you write the job advertisement in a way that it is so unattractive to the Jewish community so they would never apply for it. And again, this is something that you might find out by comparing yourself with others. And you use that to bring a claim. You say there is something off and something needs to be done. That element of feeling injustice, being treated unfairly, is now completely eroded in the online world. Why? Because algorithms are doing the dirty work for humans. They can infer all those sensitive information about you before you even find the job advertisement. So your clicking behavior, your reading behavior, your mouse tracking, and what you shop online is being used to infer if you're a vegan, if you're of Jewish faith, if you're a woman, if you're Black, and then you're being filtered out. And when you start looking for a job, the only thing that you will see is no results found. So you don't even know that you have been filtered out. You don't actually know that you're being discriminated against. You only see one version of the truth and not the whole truth. So that feeling of injustice will be eroded and will prevent you from actually bringing a claim. And again, this is just for job advertisements, but actually the problem is much, much deeper. It's not just jobs. It's basically everything that we see on the internet. It's the search results that you see on Google or on Bing. It's the tweets that you see on Twitter. It's the posts on Facebook. It's the price on Amazon. Everything is being tailored to you. Everything is being catered to you. You only see one version of the truth and not the whole truth. And this is actually what it looks like. You have blinders and you don't know that you're being filtered out or being discriminated. And that will make it very, very hard to bring a claim because you just don't know. Second problem that we face is that, again, apart from that it's hard that you don't feel it, the other problem has to do with the evidence that you will need to show in court to show that what an employer or what a company has been done to you is discriminatory. And again, in most cases, it was easier because you would come back and say, well, they used hair length, they used headscarves, they used whether or not I'm married or not to make a decision about my future. Now algorithms are using data that are unintuitive and don't necessarily make your alarm bells ring in the same way that we have done in the past. And that will make it much, much harder to bring a claim. To give you an example here. So this is Fia. This is my brother's dog. He adopted her a couple of months back. So that's the latest member of our family. It's an adorable little puppy. So let's just say I found an interesting correlation between dog ownership and being a great chef in a restaurant. I could even come up with a story around that and say people who have dogs are more playful. And if you're more playful, then you're more likely to come up with new and creative and exciting dishes. And that could be the whole explanation around that. So it might be odd to use dog ownership as a factor to hire somebody, but it's most certainly not illegal. And it's not going to make your alarm bells ring in the same way like hair length or height or whether or not you're married would be. But the thing that you don't know is how dog ownership correlates with protected attributes. Why did I use that example? Because for years now, I have tried to adopt a puppy as well, but I have failed. The problem is that, for example, here in the UK, it's almost impossible to have pets if you are renting. So for the last years, I've tried that, but because I'm renting, most of all my tenants have said I can't have it, as opposed to my brother who lives in Austria, where renting and having a pet is no problem whatsoever. So without knowing, you will find out that having a pet in the UK is only possible if you're also owning property. In other words, if you own a house. And all of a sudden, dog ownership is a proxy for wealth, which you didn't know about because you didn't know about UK's particular situation when it comes to pets. So all of a sudden you have a proxy for wealth, and once you have a proxy for wealth, you have a proxy for race and you have a proxy for gender without actually knowing. And that is one of the biggest problems that we face now, that we don't actually know how untraditional data relates to protected attributes and groups. You could also make the argument, well, maybe dog ownership is not correlating with race and gender, but all of a sudden you're using dog ownership to make very important decisions about people's lives, and you are creating a new group. So, seeing an interesting correlation with liking or having dogs then opens up the possibility of getting a job, getting a grant, getting into college, getting a insurance, and you all of a sudden have all those knock-on effects. and you are creating a new group that is not protected under non-discrimination law. Liking dogs, having dogs, could be something that could be very detrimental in your life, and dog ownership is obviously not of the traditional groups that we have protected in the past, because dog owners were not stigmatized in the past. So without knowing, you're creating a new group that is suffering disadvantage but doesn't find the same protection under non-discrimination law. And that is something that we really need to tackle when it comes to data-driven decisions. Okay, how do we square that cycle? As I said, the problem is that on the one hand, the law is very flexible, and that will make it very hard to automate fairness in a meaningful way. And at the same time, the legal community probably needs to adopt a bit more of a coherent way of assessing things, because the intuition that they used in the past is not going to be good enough to detect novel cases of discrimination. So what we're trying to do in that paper is to say, both sides really need to learn from each other. The tech community needs to embrace the contextual nature of non-discrimination, accepting that social inequality is deeply contextual and will depend on very, very variables that are so much more diverse than ones and zeros. At the same time, the legal community needs to understand that data-driven decisions cannot always be detected by looking and being guided by intuition. We might actually need some statistical evidence that show you something that you wouldn't be able to see if you just did go with your gut. So what we're trying to propose here is somewhere of a middle ground to say, we are arguing that we should have consistent assessment, but not interpretation. We want to try to bring together a type of statistical evidence that allows you to assess and flag up discrimination without giving a predefined notion of fairness first. So trying to square the cycle in that way. So the way we try to do that is try to figure out what kind of statistical tests would be helpful to do that. And many of you will know that there is a very vibrant, fantastic community in the science literature that deals with questions of fairness and is trying to figure out what fairness actually means. And we try to do a similar thing, but we try to look at it from a legal perspective. So rather than looking at fairness from a scientist perspective, we try to figure out what does fairness actually mean from a legal perspective. What is it that the court thinks is fairness, and take it from there rather than to separate that. It was actually quite challenging, because what we wanted to do is to figure out what does the court think is fair, and what statistical measures that we currently have matches that description the closest. And it was hard because, as I said, the court is not very coherent in the way that it's making decisions. So yeah, that was a big problem. As I said, one of the things how indirect discrimination is being assessed is that you look at a rule that is applied to everybody else, and you need to show that it's disproportionately affecting a specific group. So pork eating requirement will disadvantage, for example, the Jewish community. The way that the court usually does that is that the court only looks at the disadvantaged group and looks at the makeup of the disadvantaged group and is saying, okay, 60% of the people who are not getting the job, 70%, 80% of those people are actually Jewish people. This is a problem. This is what we call negative dominance. That makes a lot of sense if you playing around with real life cases where the social inequality is immediately apparent. However, the problem is if you use that arguing in the intuition and translate it over to statistics, it could be a big problem if you're only looking at the disadvantaged group. Why? Because that threshold of at least 50%, and in most cases it will be higher, 60, 70, 80%, is extremely detrimental, and I cannot stress this enough, extremely detrimental to minority groups and for intersectional discrimination. Why? Because those people never will make up, or in most cases won't make up 50% of the disadvantaged group. And if you're only looking at disadvantaged group, you actually cannot see the systemic discrimination that goes on. And you could do something what we have coined divide and conquer. So by strategically putting, having different groups and making them smaller, you could hide the fact that you're discriminating against them. So for example, you could come up with a reason why you have, let's say, Asian women, Black women, white women, And all of those make up less than 50%. And it never actually flags up as being discriminatory because you don't hit the 50% mark. However, if you only had women, it would be beyond that. So again, by only looking at disadvantaged group, you're opening yourself up to the risk of being discriminatory because you're part of a minority and because you're part of intersectional discrimination. And again, if you only use statistics to translate what the courts have done into the online world, you will exactly hurt those people who need the most protection. So we figured, okay, that's not good. Let's not do negative dominance. Does the court have any other ideas of how to assess non-discrimination? And again, it was a very hard conquer to do that, but the court actually talks about a certain gold standard of comparison. In the 70s, for the first time, and in follow-up judgments, at least in 5-6 other instances, the court talks about how you should assess non-discrimination. And you should assess it by looking at the composition of the disadvantaged group and the advantaged group and compare the groups that you're interested in. So rather than just looking at the disadvantaged group and that makeup that actually doesn't tell you about how the whole population is treated, you should look at the advantaged group and the disadvantaged group at the same time. So that is what the computer scientist literature will say about parity, group parity, group fairness. The problem is, though, that when it comes to conditional to demographic parity, that this can be highly flag up non-discrimination where there isn't actually one. So interesting example here in the 70s with Berkeley's admissions, where there was a suspicion that women are being disadvantaged when it comes to university admissions, because on head count, they were rejected at a higher rate than men. However, once they conditioned on the departments, what they found out is that not only are women doing better, men are actually doing worse when it comes to being accepted to university. The main reason was that women on average were applying for departments that are higher, where there were less seats available, and they were more competitive. But even in those, they would get in at a higher rate than men. So at first instance, your intuition would tell you, well, this looks discriminatory against women, but in fact, it wasn't. It was actually discriminatory against men. So the conditional element was very important. So to square that, this is why we propose conditional demographic disparity, not just demographic parity. And that would actually try to solve both of the problems that I just told you about. It would remove that potential noise, that additional false positives, if you will. And the other thing it will do, it will help you to detect minority-based and intersectional discrimination that negative dominance would not do. So it would actually, be the best of both worlds, but also be very compliant with what the law actually would. So conditional demographic parity, in short, is what the court thinks is fair and is the closest statistical measure that we have to assess that. Finally, what I want to say is that this is not a solution in order to make a subjective assessment about fairness whatsoever. Conditional demographic parity is not there to assess the contextual elements and the contextual equality elements that the law wants to leave flexible. We see conditional demographic parity more as a map that shows you where to look, but not what to think. It is supposed to remove the blinders that you have because intuition might not be good enough to flag up certain types of discrimination. Those types of discrimination where your social gut doesn't tell you, oh, this is wrong because they use hair length or they use whether you're married or not. All those very, very untraditional data sources like puppy ownership that could be discriminatory could be flagged up with that statistical measure, but it doesn't tell you whether it's right or wrong. This is something that is left to the judiciary to do. So the question is, are you part of a protected group? Is the legal disparity justified? Is the damage severe enough? Who is your comparator? All of those things keep are going to be contextual as they were in the way that the law wants it. What we're saying is that the type of summary statistics will just show you where potential inequalities could be. And that can be beneficial for a host of people. It would be very good for the judges, because the judges then will be able to see on a statistical basis where inequalities actually occur. It will be very good for the claimants, because they now would have access to the data and it would level the playing field for them. And it would be very good for companies, because they could start testing their own systems on a regular basis before cases actually occur, because they might not be aware that the data that they're using or the algorithms that they're using are discriminatory. But those types of tests would tell them beforehand, and then they could screw it back and make sure that parity is achieved. And that will be that is the contribution that we want to promote. So to conclude by saying, even though I started off with a lot of very, very problematic examples, I think that AI can actually help us to make decisions fairer, less biased, and more transparent. The challenge now is that we actually have to learn from each other, and writing that paper was definitely a learning experience for me, and I'm very grateful to my co-authors to have learned so much through that process. I think there are parts of fairness that cannot and should not be automated, because that's not what the law wants, and fairness is deeply contextual. And the computer scientists will have to make peace with the fact that equality and fairness is very, very complex and not something that can be explained in ones and zeros. At the same time, AI fairness, some parts of it can be automated and should be automated. And this is where the legal community can learn from computer science, because your social gut, your intuition in assessing unfair cases might not be good enough, alone not good enough, and you might need help of a way of coherent approaches to figure out where potential discrimination might occur. And to bring agility to computer science and bring cohesion to the law, we propose conditional demographic parity to square the cycle, to make sure that we can use automated decision making to make fairer and less biased decisions, and promoting human rights at the same time. Thank you very much.
Thank you very much, Sandra. That was absolutely excellent. And we're now going to move on to the Q&A section of the talk. And just to remind everyone, if you do have a question, please put it into the Q&A tab, and we're going to try and work our way through as many as possible. So first of all, would a major benefit of algorithms in decision making be that they do not see things as binary as we do? They do not see the world in black and white, whereas humans usually do, and are quick to put a label on things.
Yeah, I think what's important to keep in mind is that there will probably not be a tech solution for any social problem whatsoever. Like in the rarest cases, you will find a technology that will solve the underlying social inequalities in our world. Algorithms are very good at showing you a problem because they will just flag up, disproportionate effects on certain groups. But that is basically forcing somebody to look into a mirror and to say, this is a problem, now we need to do something about it. And that now we need to do something about it is where the interesting start actually starts to happen, and where we can find policy interventions to make sure that those inequalities are being rectified. So in an ideal world, you would have those things work in tandem and try to attack inequality from various angles at the same time, because algorithms won't lie to you about inequality, but the next step then is to think about policy interventions to make sure that those inequalities are being stopped.
Fantastic, thank you. So we've got another question saying, this is very informative, thank you so much. Could you please explain if and how the concept of fairness you're describing relates to fairness under the GDPR? And so could the GDPR fairness be automated?
Right, so that's a good question. I think two things have to be kept in mind. That GDPR is a data protection framework that talks about the transparent and open ways in which data is being collected and, for example, shared. GDPR is about procedural privacy. So that means you have to ask for consent, you have to be transparent about it, you have to tell who you're sharing your data with, for what purpose you're collecting. The question of what you do with the data, how you assess the importance of the data, how important certain categories of data and variables are for you is not something that GDPR tells you, and it's not something that GDPR was ever designed to do. Really, GDPR is just about transparency. And I wrote a whole paper on that topic, which is called A Right to Reasonable Inferences, also a paper that is publicly available, where I tried to assess how GDPR is actually helpful when it comes to inferential analytics. And the problem is that it is not very good, because it's not about figuring out what is a good data use and what's fair and what's good. It's about being transparent about what you do. There's no qualitative assessment. And in fact, the Court of Justice has ruled on various occasions that data protection law is not there to assess the fairness and the openness and the transparency of decision making. That's not something that this law wants. If you have a problem about how you're being assessed and how you're being evaluated, you would need to find a sectorial law that gives you some sort of remedy. But very often we don't have that. We actually don't have, as I said, fairness is not a standalone right. There is no right that tells you how to treat people. It just tells you you can't do certain things. It's a negative right rather than a positive right. And in my current research project and in the right to reasonable inferences, I criticize that and I say, well, now it's time that we think about that. It's not just about negative, it's about positive. What would be a good standard? What does fairness mean? And that is something that I think needs to be assessed on a contextual basis and a sectorial basis. So what is good inferential and fair and ethical and normatively acceptable inferential analytics based on criminal justice, employment, education, health, all those things. And I think that's the starting point to do that. GDPR in itself doesn't tell you anything about that. In all fairness, not even non-discrimination law tells you anything positive about it. It just tells you can't do this. But actually we need to think about what should you do rather than what you shouldn't do.
Excellent, thank you. And we can actually include a link to that paper on GDPR that you're talking about in the follow-up email for those who are interested. So another question here. So do you see similar issues of AI in assessing, for example, applications for trademark registration? UK IPO is apparently going to trial AI.
Right. So I think that's a very excellent point, and something that we all need to consider going forward, that you always gonna have some type of competing interests in mind. You have on the one side people who will be pushing for data transparency and fairness, and individual-based rights and human rights. And on the other hand, you will have the competing interests like free speech and trade secrets. And it is absolutely true that in the past, this has been a big, big barrier for all types of algorithmic transparency things. I've written about this as well when it came to what types of algorithms need to be explained and what types of things should be explained. And very often the courts would side with people who own trade secret or intellectual property rights to say this is a legitimate interest not to disclose too much about how the algorithms actually work. And that is a big, big problem. And finding a middle ground that would allow you to be a company, to be competitive on the market without using that as an excuse to fundamentally disadvantage people is something that we all need to work on. Yes, fully agree.
Perfect. Do you think an EU regulatory approach applicable in all MSS of what constitutes discrimination is then a prerequisite towards AI fairness assessments? Do you foresee the extraterritorial consequences of such an approach?
Yeah. I think in general, what we will see is that in the long run, we probably need to think about a global strategy, just because technology doesn't really care about geography. And I think we have a very good opportunity in the European Union to set a standard there. Currently, unfortunately, we have only non-discrimination directives, which have to be interpreted by the member state, which leads us in this unfortunate situation where we have so many different interpretations. We've had that with data protection law as well. For 20 years, we had a directive with varying standards. And now with GDPR, we for the first time have that harmonized standard. So I really, really hope that moving forward, we will have regulation that will be applicable to all member states in a way. In fact, for over 10 years now, there has been a framework proposed that would actually strengthen the rights of certain communities who don't get enough protection at the moment. So as I told you, the third group, which is based on sexual orientation, age, and disability and religion, is the group that has the least protection in the European law. And for 10 years now, there's a draft that was trying to strengthen those rights, but for political reasons, this didn't go through, which is very, very problematic. But that is, in fact, a way of how I think we should move forward to higher the minimum safeguards for those communities to make sure that those rights are being protected. A fragmented standard is usually just something that allows a race to the bottom, which is something we need to avoid at all costs.
Thank you. And I think we've got time for one last question here. So thank you for your excellent talk. Have you come across Google's fairness indicators? And to what extent might they contribute or fall short of your articulated goal of squaring the circle?
Right. I think in general, that is, I think it's very positive that we all trying to figure out solutions in a way. And I'm very grateful that everybody who is working in the tech community, be it industry or be it the public sector, is trying to think about fairness. I think what fairness means, though, is something that needs to be assessed by a body that is representative, democratically legitimized in a way. This is not to say that we shouldn't have a broader discussion around that and finding consensus, but it's very important that we distinguish between what you can test for and how you evaluate what you find. And I think that's what we try to do with the paper. Having the statistical test we're proposing is something that could be easily implemented by tech giants like Google, Facebook, Amazon, but that doesn't necessarily mean that you immediately know if something has gone right or wrong. That contextual element still needs to be assessed. And the more conversations we have in that community to figure out what is actually good behavior, what's ethical behavior, will make the transition much, much easier. And I think nowadays, this is the perfect timing to figure out what we actually expect from our society. What we expect from humans? What do we expect of algorithms? And having that dialogue right now will be very good, because in that way, we can actually shape how policymaking is being done and how business practices are being done.
That's wonderful. Thank you so much, Sandra. Unfortunately, that's all we've got time for today with the questions, but we will, of course, keep a track of all the questions and try and answer some of them in the follow-up email, which will be coming out in due course. Thank you particularly, Sandra. That was a very educational talk where, I mean, I certainly learned a lot, and it was on such a topical matter as well, which was very, very interesting. So thank you for your time. The OII is hosting our next session on data science, get us out of here, which is the recommendations for resilient and fair policymaking in a crisis, featuring Professor Helen Margetts from the OII next Wednesday, the 17th of June at 1 p.m. UK time. So please visit the events page to sign up. Thank you again, Sandra. It's been a really fascinating talk, and we wish you all a wonderful day.
Thank you so much. Thank you for taking the time. And yes, feel free to shoot me an email. Thank you so much for coming. It was wonderful to speak to you today.
Thank you, everyone. Goodbye.